compare the writ jurisdiction of the Supreme Court with that of High Courts under the Indian Constitution? Ans. Article 32 of the Constitution of India provides one of the most important constitutional remedies. It gives right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by Part 3 of the Constitution. For the enforcement of the fundamental rights, a parallel writ jurisdiction has been conferred on the High Courts under Article 226. As regards the interrelation between the two articles, it appears that Supreme Court's jurisdiction is independent of and is in no way curtailed or qualified by the jurisdiction of High Court. A person aggrieved of violation of his fundamental rights may come straight to Supreme Court for relief, and he is not bound to invoke the jurisdiction of the High Court first. The reason is Article 32 is itself a fundamental right and provides for remedy in case of violation of fundamental right. In Gopal Das v. Union of India, AIR 1955 SC1, Supreme Court observed that the sole object of Article 32 is the enforcement of the fundamental rights guaranteed by the Constitution. Whatever other remedies may be open to a person aggrieved, he has no right to complain under Article 32, where no fundamental right has been infringed. In Kochuni v. State of Madras, AIR 1959 SC 727, the court held the view that Article 32 is the most powerful weapon in the hand of the Supreme Court of India. With this power, it keeps the legislature and executive within bounds of their respective powers. In Fertiliser Corporation Kamgar Union v. Union of India, AIR 1981 SC 345, it has been held that the jurisdiction conferred on the Supreme Court by Article 32 is an important part of the basic structure of the Constitution because it is meaningless to confer fundamental rights without providing an effective remedy for their enforcement. When they are violated, Parliament may empower the Supreme Court with such a power under Article 139. But the power of the High Court to issue writs cannot be in derogation of the Supreme Court under Article 226. In other words, an order under Article 32 will supersede the orders of the High Court previously passed. The power of the Supreme Court to issue writs under Article 32 is a bit narrower than that of the High Courts under Article 226 of the Constitution. Under Article 32, a writ can be issued only for the infringement of fundamental rights guaranteed under Part 3. But under Article 226, writs can be issued for the infringement of the fundamental rights or for any other purpose. Thus, the High Courts enjoy a wider power under Article 226 to issue writs, orders, or directions. Following are the cases in which application of Article 32 does not lie. 1. In Sadhu Singh v. Delhi Administration, AIR 1965 SC9, it has been held that the court will not under Article 32 interfere with an administrative order, however erroneous, where the constitutionality of the statute or the order made thereunder is not challenged on the ground of contravention of a fundamental right. 2. Article 32 of the Constitution is not directly concerned with the determination of the constitutional validity of a particular legislative enactment. To make out a case under this article, it is incumbent upon the petitioner to establish not merely that the law complained of is beyond the competence of the particular legislature as not being covered by any of the items in the legislature list, but that it affects or invades his fundamental rights guaranteed by the Constitution, of which he could seek enforcement by an appropriate writ or order. Chiranjit Lal v. Union of India, 1950 SC 109. Clause 1 of Article 32 guarantees the right to move the Supreme Court for seeking relief from the court by way of 5 writs as contained in the clause. The Supreme Court of India may not only issue above writs but also directions orders or writs similar to the above so far as to fit in with any circumstances peculiar to India. But the remedy must be sought within reasonable time. In Sommawanti v. State of Punjab, AIR 1964 SC 131 Supreme Court has held that where the suspension of fundamental rights has the constitutional protection, Article 32 will have no operation.